CF 612. Mr. Koffield is present, and
I think this is the arraignment for his violation.
yes.
I've not had any feedback from the state yet as far as how they want to proceed. Mr. Koffield did submit a new polygraph result because his first one was ruled inconclusive by the examiner. I guess we could just enter a plea of not guilty and set it for evidentiary hearing at this point.
Okay. What's the state's position?
Ma'am, we have no objection to an evidentiary hearing. The original underlying polygraph and the violation it's based on was back in March of this year. It was inconclusive. They thought he was uncooperative. The subsequent one looks like it was done in August. The recommendation is to revoke his probation and to place him on sex offender community control, and that would be the state's position at this point. But if he wishes an evidentiary hearing, he certainly has a right to that.
All right. How long do you all think you will need for the hearing?
It might be an hour or two. I don't know. Depends on how many witnesses we need to call. That's more on the state side of things than the defense, probably.
I wouldn't think it'd be more than an hour, ma'am, half hour.
Okay.
Let's do it.
Well, then, I think my
Certainly,
first,
Mr. Lavelle, we can talk before that as well.
I think my first available date is going to be in October, so you'll have to get with Amanda to schedule that. Because that would be a special set. If you need more than 30 minutes, we'd need to set it on a Thursday, most likely.
It may take a while. This is kind of an issue of first impression and what I've been able to see regarding a violation based on a polygraph result. So it may be 30 minutes of testimony, but 2 hours of argument. I don't know. I mean,
Yeah, so that's why we need to.
Yeah, so that's
special
fine.
set.
We'll set it up with your assistant.
Yes.
Okay.
So for right now, let's go ahead and just schedule the next court date, just regular docket day type court date. So that would be October 21st at 9 o'clock. But that's just a docket call. That wouldn't be the evidentiary hearing. We would need to special set it. So I am going to ask the attorneys to reach out to Amanda for dates. And if y'all could do that within the next week, that would be great because the dates are filling up.
Does the court anticipate a date that would occur sometime in October or November? Or? Yeah, I don't know.
I mean, if I knew the schedule, I would give you a date right now, but she special sets anything more than about 30 minutes. She'll special set it, and she keeps the calendar. So I just don't, I mean, without logging into the system, sending her a message, I mean, it's just, if you could just reach out to her, she'll
Okay.
give you dates.
All right, understood.
Thank you. So our regular court date, though, is October 21st at 9. You'll just need to reach out to her for a special set date for that evidentiary hearing.
All right, that's just for status then, okay.
Correct.
I just we've never scheduled VOP evidentiaries that way before, so it's a new occurrence for me.
How did you used to schedule them?
The court just set them on a
regular day?
on a miscellaneous.
I've had
afternoon.
VOP hearings that have lasted 2 hours before, so, then we're here till late. So I'm trying to avoid that. We are going to, if you think you need more than 30 minutes, we're going to special set it.
I don't want to presume, so that's fine.
Okay.
Thank you,
So,
Heather.
sure.
Okay, have a good day.
Thank you. So, Mr. LaPella, when you're ready to recall your other client, just let us know. Mr. Sutherland?
Yes, good morning, Judge.
Good morning.
Jared Sutherland here on behalf of Miss Celeste Gail Johnson. This is case number 4623 CF 001459. And today
Wait,
we
just
are...
one second.
Yes, ma'am.
Let me find that on the docket. And I think it's number 10 on my docket. Okay, and the defendant is present.
Yes, ma'am.
Okay.
And today, we are entering a plea, where we're admitting to the violation of probation, and we're resolving it with the negotiated plea agreement, which has been provided by the state.
All right, great.
And may I approach with the score sheet and the plea?
Yes.
Thank you so much.
Thank you. Thank you. Okay, thank you so much. All right, ma'am, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down. And if you'll just tell me your name, please.
Celeste Gail Johnson.
Thank you. You're here on allegations that you violated your probation in case 23 CF 1459. It looks like there was an amended affidavit filed on July 31st with 4 allegations that you violated your probation. Have you had a chance to talk to your lawyer about the allegations and any possible defenses?
I've been in contact with my lawyer the entire time. Yes, ma'am.
That's great. Have you discussed this plea agreement with your lawyer?
2 times. Yes, ma'am.
Great.
A couple times.
And did you read and sign the agreement?
Yes, ma'am. I did.
Is that your signature on the last page?
That is my John Hancock. Yes, ma'am.
Thank you. Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes, ma'am.
Are you entering the admission freely and voluntarily today?
100%. Yes, ma'am.
Is anyone forcing you or threatening you?
Absolutely not.
Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Absolutely.
Great.
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am. I have not.
I do have a score sheet that shows 42.8 total sentence points. Any objections?
There's no objection to that, ma'am.
Okay. Ma'am, you're getting very close to scoring prison. So talk to your lawyer about that, but it's going to be critical that you comply with community control because you're getting very, very close.
There's no messing up. Yes, ma'am. I understand. No messing up.
Are you admitting all 4 of the allegations in the amended affidavit filed on July 31st?
Yes, ma'am, we are.
Ma'am, are you?
Yes, ma'am. Sorry.
Okay. I accept your admission. I find it was freely and voluntarily entered. I do find that you have violated your probation based on your admission, and in accordance with your plea agreement, your probation will be revoked and terminated. Looks like you were previously adjudicated guilty of the offense, and we'll place you on a new term of supervision, which will be 18 months of community control. And you must have a substance abuse evaluation followed by any recommended treatment. You must have that evaluation within 30 days. And you also must complete 24 hours of community service work. And I'm going to address the costs in just a second. Did I cover the terms?
Yes, ma'am. I just wanted to clarify with the court that Ms. Johnson is anticipating moving soon. So I guess she would just inform her community control officer of any changes of address, correct?
I think she would. Is that Officer Varese?
Yes.
Okay. I'll let Officer Varese speak to that.
It would have to be verified before she can move, of course.
Yes, ma'am. Thank you.
It would be her officer that would be.
Yeah, in Shalimar? Where's your office in Shalimar?
No, it's on, I think in Fort Walton, it's on 13 County.
Oh, same place as the one. Yes, ma'am, sorry.
No problem. So as to the court costs, there would be a $100 VOP cost of prosecution fee. And then I don't think there was ever a court appointment.
No.
Okay, just the $100 cost of prosecution? All right, so that's the only additional cost. That's in addition to any previously imposed costs or fees. And then, of course, there's the monthly cost of supervision. Did I leave out anything?
No, ma'am, that's the terms that I'm aware of on the plea offer. Yes, ma'am.
All right. Ma'am, you have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Thank you.
Is this the only thing holding you in jail?
Yes, ma'am.
Okay, so see officer of arrest before you leave the courtroom. You should get out today. I don't know what time, but you'll need to, officer of arrest, won't she need to check in tomorrow morning?
Sorry?
Won't she need to check in tomorrow morning?
If she can check in today, if she gets
Today.
released today, then they would like to see her before 5.
If she gets out of jail before then, in time to get there before 5, then check in today, but I don't know when you'll be transported back up to Crestview and processed out. So if you don't get out in time to make it before 5 today, go first thing in the morning before 9, okay?
Absolutely, yes, ma'am.
All right, good luck to you.
That's all I have, ma'am. May I be excused?
Yes,
Thank
thank
you so
you.
much, Judge.
Ms. Merrifield?
Yes, ma'am.
All right, let me get Zoom going. I believe you have someone appearing by Zoom.
Yes, Judge. If I could take the one on Zoom, it'll be Brito Wilson, 24 CF 1620.
Okay, just one second, I've got to get Zoom up again.
And that one may be listed under Attorney Rollo. I don't know why my notice isn't showing.
So I don't show one in the case. I just don't see one.
I didn't see it on the docket either. We did file one.
For some reason, I saw it somewhere because I have your name. I mean, I knew that
Yes,
you
ma'am.
were on that case. Let me just find it on my docket, though.
When I checked this morning, it was still under Rollo with an R.
Yeah, I must have seen your motion. Maybe that's how but I knew that you were on. Let me bring in your client who is on Zoom. So we're here in case 2014 CF 1620 on a petition for seal of record. And sir, on Zoom, can you hear me?
Yes, ma'am.
Okay, great, thank you. If you'll state your name, please.
Michael Brito Wilson.
Great, thank you, sir. I'm Judge Clark, and your attorney, Ms. Merrifield, is here.
Thank you, Judge. We're here today on Mr. Brito Wilson's petition to seal his record in 2014 CF 1620. A valid FDLE certificate of eligibility was received on June the 23rd, 2025. It's my understanding that the listed victim in this case had no objection to Mr. Brito Wilson receiving an expungement.
All right,
That's correct, Your Honor. I did speak with the victim. She's actually here early this morning as well. She relayed to me twice now that she has no objection to the expungement, so the state has no objection either.
all right, great. So are you seeking to seal or expunge?
We're seeking to seal.
Okay, well
No
then,
objection to the sealement, Your Honor.
great. So I reviewed the file, I reviewed the petition and the attachments, and I'm granting your petition, and I'm happy to sign an order.
I do have a paper order.
Yes.
If I may
I'll take it.
approach?
Yes, of course, thank you. Oh, thank you so much. I'm going to sign it right now.
All right, thank you, Judge. And I do have another evidentiary that also didn't show on the docket. I need a few more moments for that one for my client to arrive.
Okay, what is that case number?
So that is Mr. Gonzalez in 24 CF 1083.
Okay.
Yeah, give me just a second. I just need just a
Stevens is present. And who do I have representing the state?
Robert Little for the state, Judge.
Thank you. And we're here on the state's motion to compel defendant to provide fingerprints. That was filed in February. And what is the defense's position? Is the motion opposed?
Judge, based upon our review of the law, it seems that it's pretty clear that they're entitled to it.
I thought so too, but, okay. So it doesn't sound like the motion is opposed, so therefore the motion is granted. Could you please send me an order?
I will send you an order, Judge. I don't know if defense counsel is opposed to having court security just print the defendant here in open court.
Any objection to that?
I would expect that would be the only way they'd accomplish that.
Okay, then that's granted as well. I still need an order so
Yes,
that
Your
the
Honor.
court record is clear that the motion has been disposed of.
Thank you, Judge, and that's all I have. Be excused.
Judge,
We'll wait just one second.
Judge, if we can
Yes.
approach on Mr. Stevens' matter.
Sure. Okay. Yes, go ahead.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in
All
bettering
right,
your
so
health,
in
we'd like to
Mr.
invite you
Stevens'
to stop
case,
by.
so the fingerprints got taken, correct? Great, all right, so that's done. We're talking about trial going to be the week of December 29th, but we'll address that more at the next pretrial conference, which I believe is October 15th at 9. Okay, and Mr. Little, if you could just send me an order on the fingerprint motion so that the record's clear that the motion was taken care of.
Yes, Your Honor.
Okay, thank you. Anything else I need to address on Mr. Stevens' case?
No, Judge.
Okay, thank you.
That's all I have, Judge.
Yes, thank you.
Judge, I have a plea.
Yes, I know you have more.
Judge, Jay Patel on behalf of Darius Clemens, 24 CT 2480. I know where my client is, but I'm not sure where the prosecution is.
All right, so case number 24, CF 2480. And, sir, are you Darius Clemens? Yes, ma'am. All right, thank you. I'm Judge Clark.
Yes. Judge, at this time, this is a change of plea. Mr. Clemens is tendering a plea of no contest to the charge as listed. Sale, manufacture, deliver. The understanding is on count 1, it would be 615 court costs due within 90 days. Any credit for time served and apply any cash bond. I don't believe that there was one.
I think I have, it looks like it's a bondsman.
Okay. May I approach?
Yes. Thank you so much. Is it 6:15? All right, Mr. Clemens, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you, sir. You can put your hand down. And if you'll just state your name for me, please. Thank you. In case 24 CF 480, you're charged with 1 count of sale, manufacture, deliver, or possess with intent to sell, manufacture, deliver a controlled substance, and that's a 3rd-degree felony. Have you had a chance to talk to your lawyer about the charge and any possible defenses?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Okay, it looks like this is an electronic signature, and there's no way you're going to be able to see it from here, so I'm going to have court security.
Judge, he's reviewed that document.
Okay.
So you can ask him about it. I've already reviewed it with him.
I just want to make sure that he's going to verify that he actually signed it. Thank you. Is that your signature, sir? It looks like an electronic signature. I just want to make sure you signed it and you read it.
Yes, ma'am.
Okay, thank you. Thank you. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to go to trial?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you? Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours? I do have a score sheet that shows 22.6 total sentence points. Any objections?
No, Judge.
Any exculpatory DNA?
No, Judge.
Thank you. And I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand the plea could subject you to deportation? All right. And do you understand that an adjudication of guilt on this charge will likely result in your driver's license being suspended? All right. How do you plead to count one? I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt, and you are sentenced to time served, $615 in court costs, and that is due within 90 days. After 90 days, if you haven't paid some or all of it, it will go to collections. That would further affect your driver's license. So, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank you.
Thank you, Judge. May I be excused?
Thank you, yes. All right. Mr. Nopes.
Good morning, Your Honor. I've got John Burkos, 23 CF 2379. Judge, the state and I have reached an agreement as to the resolution of this matter. It is a violation of probation, but it was only because of money and community service work. So we've agreed that if he'll admit the VOP, that we'll continue, the court would continue to withhold, and he'd have to complete the original requirements plus a $100 VOP fee plus a $150 court-appointed legal assistance fee. So we've agreed to extend it for 6 months.
All right.
I don't have a plea agreement, Your Honor. Do you need me to do a plea agreement?
I do want
Okay.
that to be in writing so that he can read his rights and
Absolutely.
there are no misunderstandings.
Absolutely.
So I'll call you back up.
Absolutely. Thank you, Judge.
Sure, just let me know when you're ready.
Judge, I'm ready.
Okay, come on up, Ms. Merrifield.
Thank you, Judge.
Yes, and
So this is Mr. Emilio Gonzalez, Brady Merrifield on his behalf, and it's 24 CF 1083.
okay, and just one second. Let me pull that up. I was trying to get my computer going, but have not had a chance to pull up his case yet.
Yes, ma'am. And we're here on his petition for expungement.
Okay. I'm going to have to log into a different system.
And Judge, I do have my copy if you'd like to review that.
Oh, that would be fantastic.
Yeah, if I may approach.
Yes, thank you.
The exhibits, it's all stated.
Thank you so much. 24 CF 1083, Emilio Gonzalez, and we're hearing a petition for expungement.
It was filed on August the 4th, Madam Clerk.
Thank you. All right, I've reviewed the petition for expungement, and what is the state's position?
The state reached out to the victim per Marcy's law. The victim does not agree with the expungement. However, she lives out of state, not going to be able to make it to testify. She actually doesn't wish to testify.
Okay.
That's my representation for the victim. The state has no position on the expungement other than the victim's position of they don't agree to it.
Okay. Do we know if the sheriff's department has a position?
No, Your Honor.
And I just have argument, Judge.
Okay. I do have a question, and it's been a little while since I've actually looked up the statute on expungement. I would assume this is not one of the excluded offenses, or else you wouldn't have filed the petition, but I'm just verifying.
So it would typically be an excluded offense unless the case has been dismissed by the state.
Okay.
And this case a no prosecution was filed on August the 5th, 2024, and the reasoning was inability to prove the charge.
Okay.
So although it would typically be an excluded offense if there was any level of adjudication, it's not in this instance because the state filed a no prosecution.
Okay.
That's correct.
Okay. Just checking. All right, argument, go ahead.
Yes, thank you, Judge. So after the no prosecution was filed based on the inability, Mr. Gonzalez complied with 943-0585 subsections 1 and 2 in that his case is eligible. He did receive a valid certificate of eligibility from the FDLE on April the 28th, 2025, and he has no prior criminal history, which, as the court's aware, those are conditions precedent to being able to satisfy the rule requirements. And satisfaction of those rule requirements does create a presumption in favor of expunging. So we are asking the court to expunge this record. In light of the particular charged offense, we do understand that gives the court pause, but I think what is most important here is that it was dismissed based on an inability to prove the charge, not that Mr. Gonzalez entered into any sort of agreement or any sort of probation. This was all done during the discovery phase. I personally represented him in the pretrial and discovery phase when the case was dismissed.
I'm granting the petition because I would let you argue, Mr. Sprouse, but you said you don't have a position. But if you wish to be heard, I would.
Correct. There's no legal basis for an objection other than the victim's disagreement.
Okay. In light of the no prosecution being filed, I am going to grant the petition. And Ms. Merrifield, I took the liberty of removing the staple from the document you gave me because you had the proposed order attached, and I have.
Judge, I actually have an updated one that, because that was filed in August, if I could approach with that.
Sure.
This one's dated for September.
Okay, I will shred that one. Sure. And there's your petition back. I will sign this.
Thank you, Judge.
Sure.
And that should be all I had on today's docket.
Thank you very much. Good luck to you,
ma'am.
sir. Thank you. Thank you. All right, here is the order. All right, Mr. Lupella, are you ready?
Back before the court with Lacey Sutton.
2019 CF 983, 2019 CF 984, 2019 CF 985, and 2019 CF 2905, and the defendant is present.
I think we've reached an agreement, subject to the court's approval, in which Ms. Sutton would be entering a plea of no contest. And
Well, this is a VOP, so it's
Or-
either admit or deny.
well, an admission, but with the idea that, with the understanding, the joint understanding that she has an inability to pay and the basis is financial violation. So pursuant to an agreement, to that agreement, she would enter an admission to inability to pay, which is put forth in the terms of the plea and sentencing agreement. Within that agreement, her probation would be terminated and proof of community service completion has been shown. Outstanding financials would be reduced to a civil lien or judgment. Specifically, there's restitution payments that are still outstanding that she would have to show proof of payment within 30 days. After talking to my client, she's indicated that she's able to pay those folks. And I'll give the court the form here in a second. And that our office is willing to facilitate payment within the 30-day period. And I've got the names and the amounts listed here. And I believe that's what we have. If I get approved.
Wait just one second, let me pull up the case, because I did look at this last night, and I mean, if your client's going to pay within 30 days, why don't we just continue the hearing so she can pay?
So that's fine.
I
We can
mean,
do that too.
And, I mean, I can't help but wonder if the issue is an inability to pay, or you're privately retained, correct?
That has nothing to do with whether or not she can afford to pay.
Okay.
Because
So-
I could be hired from anywhere.
Right, okay, but I
So-
mean, it does, you know, I am wondering, but, so why don't we just continue the case and let's see the payment get made, because I actually want to look, I didn't write down the amount on my docket, but I think one of them was quite a bit, at least one of them, so let me just pull that up. And do I have Mr. Snell here on behalf of the state?
Yes, ma'am. Would it be okay if we approach?
Sure,
Okay.
sure.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You been injured in an accident and need righteous representation? Call us, because we fight fire. damn thing ain't working.
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Officer Varese, we do have a question about the logistics of restitution. This is Ms. Sutton, and she is going to pay, she owes some restitution in 3 cases, and she's going to pay that. Does she pay that through probation?
If her case is still open, then yes. As soon as she's terminated, then it would have to go through the clerk of court.
Okay, so her case is, I mean, she's here on a VOP for failing to pay the restitution.
And I see that she was notified on February. She's past term. She's no longer in our jurisdiction. She's no longer.
Well, wouldn't the VOP toll the expiration?
I don't know.
You're correct, Judge.
I can answer that, yeah. No, typically probation will only continue to supervise as a treasurer for the court. But once they're past the term, they don't actually report, they don't go into the office anymore. So as far as probation is concerned, they're done until they get put back on supervision.
So as of this moment, she cannot pay the restitution through probation?
No, because her case has been kind of closed and it's kind of like pending on VOP. So all her monetary obligations are closed, but we can open them up if you can, even if you just say extend her another 30 days, because I see her termination date is 9/4 this year.
Oh, okay.
She should be able to make that payment. We can open that up for her.
So she could still pay through probation? Okay, can we do that without extending, like officially extending and having to do an order extending, or can she?
We would definitely need an order to extend to open those accounts up.
Okay,
But like I said, it could always be ordered for her to pay it through the clerk of court, and then we don't have to do any of this.
okay, and so
That's really
if,
the easiest way.
I don't know if that's easiest. I know in my experience, it's kind of difficult to do through the clerk. I'd be happy to facilitate payment through my law firm. I can cut checks through the trust account. That's not a problem. I just need to be able to verify good addresses for the folks that are listed. And I have their names, and we can try to locate them. If probation or the state has access to their information, I'd readily accept it and give us 30 days to do so. Come back in a month.
would probation have, like if she's made payments previously, which I believe she probably has, would you have the,
I'm looking at them right now, but we didn't just get them from the discovery, so those are the addresses.
And I'll be looking for them as well.
okay.
I'll in my office, we'll track them down.
Okay, so why don't we pass the case to my next miscellaneous day? That's about a month from now. I think it's October 21st. So a little over a month. And during that time, hopefully, ma'am, you can take care of the payments, and then hopefully the individuals can be tracked down. So,
okay.
October 21st, and that would be at 9 o'clock. All right?
Your Honor?
Yes.
I just looked and her accounts for the restitution is still open with us, so she can make the payment through correct pay.
Thank you so much. That's great news.
And then we can come back and just continue to do the also will stay open until it's renewed.
Thank you, Officer
And,
Perez.
and then, as far as the amounts, because there was an issue before about whether or not the payments that she was making before was going towards restitution first versus court costs and other fees. Does probation, I know on one of the affidavits, they've got the numbers listed. Is that sufficient for them to be able to direct that money to the persons?
Our payment system is a mature system, so the first priority is always going to be restitution. She has, none of the money that she paid went to any of the court costs as of today.
Okay, I need, if she's gonna, I believe the total amount is $1,183.96.
To the individuals.
To those individuals, and I would just ask the court to direct probation to assign funds, if they're received in this time period, that they be directed to those individuals, which would be Kim Biglin, Marion Given, Janice Thompson.
And that, are those the 2019-983, 2019-984, and 2019-985 case numbers?
I believe so.
I think so too. So is it, let me ask Officer Perez, is it possible, I think there's restitution, or I'm pretty sure there's restitution due in 2019 CF 2905, but these payments that she's going to make would need to be directed to the 983, 984, and 985 case.
I see 3 accounts open for 3 restitution. The total is $1,183.96. Now there's a 4% surcharge to correct pay, so you need to add that, and then plus the fee that you make, that you use their services. So that's pretty much going to be the total. And yes, it will be going to restitution instead of the tier 2 accounts would be the court costs.
I think there's restitution owing in a different case, 2019 CF 2905, which I think is on a different warrant, if I'm not mistaken.
That's the state.
Right, so I want to make sure that the
that's already
funds are.
been being garnished through assistance.
So, okay, I just want to make sure that what payments she makes that's supposed to go to the individuals isn't going to go to that case where it's the state. I'm not trying to not get the state paid. I want the individuals paid first, and the state's getting its money through the garnishment, so. Okay.
And we'll get with probation, figure out exactly what that number is, plus the 4%, plus the fees.
It probably
Hopefully
calculates.
it's not too much more.
Yeah, it probably calculates it when you're trying to go online and pay it. It'll probably give you a bottom line total. So why don't we just reset the case for October 21st at 9, then those 3 individuals will hopefully be paid by then, and then we can resolve things.
Thank you, Judge.
Thank you. Good luck to you, ma'am. I'll see you next month, October 21st at 9.
Thank you, Judge.
Thank you. All right, do I have any other private attorneys present? Oh, Mr.
Judge
Notes.
John Nicholas Burkos, may I approach?
Yes. Thank you very much. All right, this is case number 23 CF 2379. And we're here in violation of probation. Raise your hand, sir, if you would, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. Could you state your name, please?
John Burkos.
Thank you. You're here on allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, Your Honor.
All right. Did you discuss this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing?
Yes, ma'am.
Are you entering the admission freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
Are you admitting the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. I'm scratching out this no contest. It's admit or deny on the VOP, so.
Yes, ma'am.
All right, in accordance with your agreement, I find that you violated your probation, but I'm going to continue to withhold adjudication on the underlying charge, and I'm going to reinstate and modify your probation to extend it for an additional 6 months. You are to complete the original requirements. In addition to any previously imposed costs or fees, the court imposes the following mandatory fees and costs. $100 VOP cost of prosecution fee, $150 cost of defense. That includes the application fee of $50. Did I cover everything, Mr. Nopes?
Yes, ma'am.
All right. Sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Please wear pants next time you come to court. Please see Officer of Arrest before you leave. You need to see her, and then you need to go straight to probation to check in. Okay? Good luck to you. Thank you.
Thank you, Your Honor.
Thank you, Mr. Nopes. Mr. Harper? Oh, I see Miss Dudley, too. Miss Dudley, would you like to? Sorry, Mr. Harper. Sure.
And I have Catherine Gellert, style, I have 23 CF 1757, 24 CF 1316, yep. 24 CF 2302, have a plea agreement if I may approach? Oh,
Yes.
take a center. Sorry.
Congratulations, ma'am.
Thank you.
Yes, I saw that you graduated from the program. Congratulations. Thank you. Thank you so much. Do I need a score sheet?
Yes, ma'am. Get it
Oh,
right here.
great, thank you. Oh, thank you. All right, ma'am, if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down. And if you'll state your name for me.
Catherine Gerhardstein.
Thank you. In case 23 CF 1757 and 24 CF 1316 and 24 CF 2302, it's alleged that you violated your probation. And let me get some clarity on which charges. Is she only on probation for the felonies?
Yes, ma'am.
Okay.
I think it's one kind of possession in each case.
Yes. So each of those cases, the charge you're on probation for is one count of possession of a controlled substance, which is a third-degree felony. And have you had a chance to talk to your lawyer about the allegations that you violated your probation in each of those cases and any possible defenses you might have?
Yes.
All right, did you discuss the plea agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is that your signature on the next to the last page?
Yes.
Do you understand you're giving up your right to have a contested hearing in each of the cases and make the state prove the allegations?
Yes.
Is anyone forcing you or threatening you to make you admit the VOP?
No.
Has anybody promised you anything other than what's showing on your agreement?
No.
Do you understand that an adjudication of guilt on these charges will likely result in your driver's license being suspended?
Yes.
Are you satisfied with the services of your lawyer?
Yes.
Did she answer all of your questions?
Yes.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No.
I do have a score sheet that shows 27.8 total sentence points. Any objections?
No, Your Honor.
Ma'am, are you admitting the allegations that you violated your probation in case numbers 23 CF 1757, 24 CF 1316, and 24 CF 2302?
Yes.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, there will be an adjudication of guilt on the felony counts on each of those cases. And the court is imposing a $100 cost of prosecution fee per case. That's a total of $300. Your probation will be revoked and terminated in each case. You are sentenced to time served in each case, and you have 90 days to pay whatever outstanding fees and costs there are in each case before they go to collections. That would further affect your driver's license. Did I cover all the terms and conditions?
Yes, ma'am.
All right. So, ma'am, good luck to you. Again, congratulations.
Thank you.
Everyone in this courtroom is proud of you.
Thank you.
Yes. We wish you well. So, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one. Good luck, ma'am.
Yeah, I'm also covering for Mr. Durrell.
Okay.
Joanna Dwire.
Joanna Dwire on 22 CF 2711 now.
All right. Yes, I have that. Thank you. And the defendant is present.
Yeah, now Mr. Durrell's asking for a continuance. He says he's in negotiating with the state to try to get a plea in this case.
Okay, any objection?
No objection from the state, Your Honor.
Okay. Then we will reset Ms. Dwyer's case for October 21st at 9 o'clock. All right, thank you, ma'am.
Yeah, and I believe that's all I have.
All right, thank you, Ms. Dudley.
Thank you.
Mr. Harper.
I have a couple on today's docket. Can I address one kind of out of order that I think should be on today's docket, but it might not be?
Okay.
It's Roger Isman,
Can you spell that last name?
I-S-M-O-N-D.
Just one second.
And I can give you the case number. It's 25 CF 1439.
Okay, let me look that up.
This was set for a bond modification, and I believe the state's amenable to the bond.
Okay, let me find the, just one second. I see your notice of hearing.
And it's going to work out, Judge. I think the state's amenable to a modification of the bond as requested, and I'll submit an order later.
That's correct.
Okay, so, okay, and your client's not in custody then?
No, Your Honor, I apologize. I don't know where he is this morning. I made him aware of it, and I've been in constant contact with him, so I don't have an explanation for why he's not here, but.
Okay. So the state is in, this is his motion and he's not present. So there's that issue. However, I mean, if the state is stipulating to the motion, then I would have signed a stipulated order and
Yes, ma'am.
he wouldn't have had to come anyway. So,
I would ask if the court would allow me to waive his appearance just for today. Again, I don't know why he's not present, but
okay.
he's an older gentleman, and I'm anticipating we'll resolve it on his next court date regardless.
All right, so the state's in agreement on the modification then?
Yes, Your Honor, and that's the victim's request.
Okay. Could you send me a proposed order, Mr.
Yes, ma'am.
Harper?
I'll do that today.
Okay. So if the state was not stipulating to the motion, I would deny it without prejudice because your client's not here. But in light of the stipulation, I will sign the order if you'll just send it to me.
Yes, ma'am.
Okay.
All right, I'll just go down the list.
Just-
Actually,
if you'll just-
whatever order you give me.
Gonzalez Montes.
Just one second, I'm just finishing the notes on Mr. Ismond.
They can. Sign the date there. Yeah, just it's a modification for 6 months.
All right, so we're here on case 2020 CF 1104, Mr. Miguel Gonzalez Montes, and he is present.
Your Honor, he's signing it now. This will be an admission. This will be a modification and reinstatement with 6 months of probation as an extension. Assess the $100 VOP fee, $150 cost of defense. Add the additional requirement of attending, completing a substance abuse evaluation and any recommended treatments. Eval within 30 days, treatment within 60. Since this is a modification, there's no score sheet, Judge, if I may approach.
Yes, thank you. Thank you.
Just make sure you're
Is this the 4th violation of probation in this case? I think it's the 4th.
If the court wants some context, I might be able to provide it.
Okay.
Judge, he's almost done with the original term of probation with respect to this charge. He violated with a charge of racing, which from a factual perspective, I don't think that there's enough to substantiate that particular allegation. However, he's amenable to having his probation reinstated so that he can resolve his violation of probation. But notwithstanding that, we intend to probably contest the racing charge itself.
And Judge, this is in accordance with the recommendation of probation.
Okay.
The report says the defendant has maintained steady residence and works 6 to 7 days a week. He's maintained a good attitude and reports as instructed. So the officer is requesting a warrant, but the officer recommends he be reinstated to add a substance abuse evaluation and recommended treatment.
Okay. And I will note that the original sentence did include it was a split sentence, so he has served time in prison on this charge. All right. Sir, if you'll just raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you'll state your name for me.
Miguel Antonio Gonzalez Montes.
Thank you. You're here on allegations that you violated your probation in 2020 CF 1104. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing in this case and make the state prove that you violated your probation?
Yes, ma'am.
Are you entering the admission freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing in this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right. Are you admitting the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, your probation will be reinstated and modified to extend by 6 months, and you must complete a substance abuse evaluation and any recommended treatment. That evaluation has to happen within 30 days, and you have to start the treatment, if any is recommended, within 60 days. In addition, you'll still have to complete any outstanding requirements that were previously imposed, and the court is adding a $100 mandatory violation of probation cost of prosecution fee and a $150 cost of defense fee. That includes the $50 application fee. That's in addition to any previously imposed costs and fees. The court does find that you are guilty of violating your probation, and I think you were already adjudicated guilty on the underlying charge. Did I leave out anything, Mr. Harper?
No, Your Honor.
All right. So, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. See officer of arrest before you leave the courtroom, and then if you get out in time to go report today before 5, you need to go today. If not, you need to go first thing in the morning, be there before 9. But is there anything else holding you in jail besides this?
He's got the racing charge, and he'll need to bond out on that, Judge.
Oh, okay, so you're not going to get out today, but...
I'm going to pay that bond today.
Oh, okay. Well, whenever you get out, if you can get to probation before 5 o'clock, go that day. If you can't, then be there before 9 o'clock on the next business day.
Yes, ma'am.
Okay, thank you. Good luck to you.
Thank you.
Marvin Garin is next.
Judge, this is Marvin Garin, 25 CF 1434.
Yes.
If I may just have a second. Judge, this is Marvin Garin, 25 CF 1434. At this time, he's going to withdraw his previously entered plea and enter a plea of no contest. This will be a plea to a lesser included misdemeanor battery, Florida Statute 784.03 sub 1 sub B. Be adjudicated guilty, placed on 6 months of probation, be assessed, I'm probably wrong, $270 in court costs, $150 cost offense, 10 to complete an anger management class, and he's asking for probation with JCS. Since this is a plea to a misdemeanor, there's no score sheet if I may approach.
Yes, thank you. Here is a blank order on Mr. Isman if you want to fill that out. That way you don't have to deal with it later. Okay. Is it 270?
No, ma'am, it's 622.
$622 in court costs.
Yes, sir. Judge, he's agreeable to that amount.
Okay. All right. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down.
Yes, ma'am.
If you'll just tell me your name, please.
Marvin Garin.
Thank you.
Yes, ma'am.
In case 25 CF 1434, your original charge was burglary with assault or battery, which would have been a life felony. Have you had a chance to talk to your lawyer about that original charge and any possible defenses you might have had?
Yes, ma'am.
Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature at the bottom of the third page?
Yes, ma'am, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
All right. Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am, very much.
Good. That's good to hear. Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
Is there any exculpatory DNA?
Not to my knowledge, Judge.
All right. I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am.
That's fine. Thank you. I just want to make sure that if you're not a U.S. citizen, you understand.
Yeah, I was born in Pensacola. So.
Okay. How do you plead to the lesser included offense of misdemeanor battery, which is a first-degree misdemeanor?
No contest, ma'am.
I accept your plea to that lesser included offense. I find it was freely and voluntarily given. There will be an adjudication of guilt on that misdemeanor battery charge. You will be placed on probation for 6 months. That'll be with county probation, JCS probation. And sir, you heard Madam Clerk mention that the court costs are actually $622 instead of the amount that's showing on your agreement. Does that change your mind about entering the plea?
No, ma'am.
Okay.
I'm fine with that.
All right. And I'm only imposing the mandatory costs. It's because of the charge. There are extra mandatory costs that I'm required to impose.
Yes, ma'am.
$622 in court costs, $150 cost of defense. That includes the application fee. During that probation for 6 months, you'll have to complete an anger management class. And this will be JCS probation. You can, I don't know if are there any barcodes up there or papers where he can? Oh, good. Okay, so you'll check in online.
Okay.
You'll scan the barcode after you get out.
Yes, ma'am.
And then that's how you'll check in and sign up with them.
Yes, ma'am.
You do have 30 days to appeal the order of the court, and if you can't afford a lawyer, I'll appoint one for you. Is this the only thing holding you in jail?
I have to purge.
Oh, okay.
So,
Well, once you get out,
yes, ma'am.
within 24 hours, check in with that barcode,
Yes,
okay?
ma'am. I will,
And
yes, ma'am.
good luck, sir.
Yes,
Thank you.
Thank you very much.
Clint Jones is next.
Judge Clint Jones before the court on 24 CF 972 and 24 CF 973. We're here for status.
Yes.
Dr. McDonald has seen Mr. Jones. What we're waiting on is her report. She is in the process of doing it. When I reached out to her, I didn't receive a response, but when I reached out to her assistant this morning just to follow up, that is one of the reports that she's working on. So it's...
Yeah, I know it's out of our control.
He
That's
did
what,
say that she has a number of cases, and she actually is taking this entire week just to
do reports?
Yes, ma'am.
Yeah. Okay, so, hi, Mr. Jones, how are you?
Doing fine. How about
Good.
yourself?
Great, thank you, sir. We are, you heard what Mr. Harper said. You saw the doctor. The doctor is writing the report. These are detailed reports. I was hoping we would have it before today. So, Mr. Harper, what I will do is schedule the case for the next usual date. But if the report comes in early and we can, I'm going to be in civil trials for the next 3 weeks, but if we need to.
Can we just put it on a miscellaneous stage, just to?
Yeah.
Because-
October 21st at 9, but
21st at 9.
if there is a, if we need to look at the dates.
If I get something shortly, because the assistant mentioned the 18th of this month, September 18th. He didn't really clarify what that meant, but if there's a quicker turnaround with respect to the report, I will send for an earlier hearing, Judge.
I mean, September 18th is in 2 days.
Yes, ma'am.
I mean, if you were to get the report today or first thing in the morning, then we would have enough time. We just have to be able to have at least 24 hours
Yes, ma'am.
to get Mr. Jones transported. So beyond that, I might have something the week of October 16th. Looks like I have an afternoon miscellaneous on that day, but
I will try to move it up. He didn't really clarify. He just noted that in file it had something September 19th or 18th circled, and he didn't know what it was in reference to.
okay. Well, thank you. Mr. Jones, we will get you back in just as quickly as we can after we get that report, okay? All right. Thank you, sir.
Have a good day.
You too.
The next case, Judge, is Rayshawn Schaffner, 21 CF 2362, 21 CF 2364, 21 CF 2399, 21 CF 3297, 21 CF 3299, 22 CF 340, 23 CF 1155, 23 CF 1156, 23 CF 1205, 24 CF 2408, and 24 CF 2049. Judge, I don't have an updated status with respect to this. When I did email her, I didn't receive a response with, I don't know if this is included amongst the reports that she's trying to work with. I do know that he's refused to meet with her, and I do know that he refused to be transported today as well.
Let me get that on the record really quickly. So Mr. Schaffner is not present. He's an inmate. And can court security confirm that Mr. Rayshawn Schaffner refused to be transported today?
Yes, Judge. He refused.
Okay, thank you. All right, so, and I know from my notes that, the last time we were in court was August 19th. He was transported, but then he refused to come into the courtroom. He refused to come out of the holding cell in the courthouse. I know that he has refused to meet with Dr. McDonald a couple times, and she did get some records, and you were going to see if she could write the report based on records and talking to his mother.
I have forwarded the family member's contact information to her and my own interactions with him, as well as any correspondence I think was pertinent to her possibly making the decision. But I don't have an update as to whether or not she feels comfortable writing a report, or if she's in fact just writing a report based on the information she has. I'm hopeful by the end of the week. This week she's in isolation apparently, but I might get an update.
So, what are the court's options? Assuming she can't write the report because he won't meet with her. I mean, if he were out of custody, I would have options, but he's in custody, so I don't know what the court's options are. If we've got a competency issue, the case is stayed until we get this resolved, and he's got 11 cases, so we can't move them forward. I mean, a lot of these cases, he's picked up because he's been in jail, they've been picked up in jail, so he
Yes,
keeps
Your Honor.
getting cases.
They move him from, if the court may recall, he's in yellow because he's
Yeah.
in max, but he's in max because of his
The cases.
behavior. Not based on his behaviors. His charges are serious, but they're not in and of themselves for something that he would be designated as max. He's in isolation. So what happens is every now and then they've moved him back into the general population. He gets a new charge, and then they move him back into isolation. And I'm hopeful that they're not moving him back into general population, but I don't have an answer as to this particular fact pattern because it's a little bit unusual. I think it's entirely dependent upon whether or not Dr. McDonald feels comfortable she can come to a conclusion based on what evidence she does have. I have not encountered this particular scenario. And the state and I discussed like what our realistic options are. And I mean, something has to happen. I just don't know what that is.
Yes, Your Honor, and that's what Mr. Harper and I were discussing earlier as to, how can we move forward with this? Because essentially, the state can't do anything right now either. So I think at this point, we'll probably have to get a report from Dr. McDonald based upon the information that she has, because I don't believe there's any other way we can move forward, and unless, Mr. Harper and I try to figure out an alternative or something else that we can do just by doing some research.
The only, it's not necessarily positive, but he has been incarcerated for a significant period of time. I'm anticipating that the offer in this matter, given the number of charges, is incarceration. I don't know if we've never really had that type of talk. But I don't have an answer, Judge. I don't know what to do at this point. I will email whatever Dr. McDonald tells me as an update.
Yeah, see, I wouldn't even be able to take a plea from him because of the competency issue. So even if there was a plea just for whatever, until we resolve the competency issue, I can't do anything. So here's what I'm considering. If Dr. McDonald cannot write a report because he's refused to meet with her and she's not comfortable writing a report based on the other materials, the records and speaking with whomever, you, family, I don't know if she's spoken to jail staff, I don't know. But if she's not comfortable writing a report, then what I'm going to have to consider doing is rescheduling, having Dr. McDonald schedule another time to go to the jail, and I'm going to have to ask the jail personnel to physically
Bring him out.
deliver him to Dr. McDonald in a safe setting, but to use force if they have to put him in front of her so she can try to do this evaluation, because all of his cases are stuck. We can't do one thing until we get this resolved.
And I understand the court's perspective. There might be given that you just brought that up, maybe the fact that he's in isolation might be a little bit different, but when someone's in medical hold, I've gone through there and I've gone into there and had the discussion with people that were not otherwise able to be transported.
Right.
I don't know if he's in that type of holding, but maybe the jail can move him to that, and that way she could go there. She might not be able to go into the isolation areas or max security areas, but she will. I'll talk to Dr. McDonald and I'll email the lieutenant at the jail to see if that's even a possibility.
That's an option. Not at this jail, but at a different jail, I've actually done first appearances talking to the defendant through a slot in the cell door.
That's how I
when they could not be brought out. So perhaps that's an option, that he could be put in some sort of, I don't know if she could be brought to the outside of his cell and try to interview him there, or if he could be put in one of those type of cells where,
Yes, ma'am.
basically it's a slot through the door and she could view him and try to speak to him through there. But if she can't write the report based on what she's got to go on, that is going to be, we're going to have to reschedule it, we're going to have to coordinate with the jail, and I'm going to have to tell the jail to do whatever they have to do to extricate him from his cell and put him in a secure setting in front of her so that she can attempt to evaluate him. And if he refuses to cooperate, then she can at least make observations. And hopefully we'll be able to gather enough from that
Yes, ma'am.
to do the report. But, I mean, he's refused to come to court for the last 2 court dates at least. And I know that there have been many other times he's refused to come to court. In fact, it's rare when he does come. But
Well, if I can clarify, Judge, there have been some times where his behavior has been such that he was not transported.
Right, right.
I don't know if that constituted a refusal, but he was not transported for security purposes.
Understood. So, Mr. Harper, can you, as soon as you find out something, if Dr. Harper, not Harper, sorry, but Dr. McDonald can write the report or not, let me know.
Yes, ma'am.
Find out when she can go back to the jail so we can coordinate, and then I will enter whatever order I need to direct the jail to do what they have to do to make him, available.
Yes, ma'am. So for logistics purposes, are we moving this to October the 21st as well?
Yes.
I think that would be possibly sufficient time.
October 21st at 9 o'clock. And please let me know what I need to do as soon as you find out
Yes, ma'am.
what Dr. McDonald is going to do.
Thank you, Judge. And I'll finish drafting up this order on Mr. Isman.
Okay, let me, sure. Ariel Berios, are you present? This is, great, come on up. This is case number 23, CF 1894, and you look very nicely dressed for court today, sir. Thank you for that. And could you tell me your name, please?
Ariel Berios.
Thank you. I'm Judge Clark. And you don't have an attorney representing you, and I know that the allegation, well, which state attorney is assigned to Mr. Berios' case?
The ASA Gainer, please, Your Honor.
Oh, okay. And did she step out for a second? I think she did. Okay. So, Mr. Berios, the particular assistant state attorney that's assigned to your case has stepped out of the courtroom. So, I will recall you as soon as she returns. I'm sorry, sir. I didn't realize it was ASA Gainer. So, do I have anyone else present who has a case today and I have not called you up yet? You do. Okay.
Yes, Your Honor. Mr. Jacob Jensen, Jensen, Your Honor, before the court, 25 CF 1222.
Yes, okay. And the defendant is present, and we're here for a status on Keaton.
Yes, Your Honor, and unfortunately, we have run into some issues with Keaton and screening at the jail. There's some confusion. Since the last court date, Mr. Jensen's bonded out. I think we're going to look at other alternatives to Keaton, so we can just move him back to the normal pretrial docket, which would be October the 13th.
Okay. October 13th at 9 o'clock.
Yes, Your Honor.
And stay in touch with Mr. Gates, okay?
Yes, ma'am.
Thank you, sir.
Thank you, Your Honor.
Thank you.
Can I get this proposed order?
Yes.
And I showed it to the state already.
Okay, thank you. Thank you so much.
Next up is going to be the code of form.
Okay.
Okay.
Your Honor, this is Dakota Ford, 2019 CF 954. The state and the defense have reached an agreement, if I may approach.
Yes.
And there is no score sheet required.
Okay, thank you.
Mr. Ford will be admitting the violation in count 1. He'll be sentenced to 60 days Okaloosa County Jail with credit for all time served as a special condition of probation. The state and the defense are stipulating that that time has already been served. Reinstate probation with all the original terms, so he'll need to be hooked up to a GPS before he's released. Maintain the current termination date, which is September 3rd, 2032. Public defender fee and cost of prosecution. And I'm going to provide this to probation.
That is the state's agreement now.
All right, thank you.
And we would advise that if Mr. Ford in the future wishes the internet access, he will need to do that via risk assessment.
Yes, ma'am.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll just tell me your name, please.
Dakota Ford.
Thank you. In case number 2019 CF 954, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation and any ways you might have to fight the case?
Yes.
All right. Did you discuss the plea agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is that your signature on the last page?
Yes.
Do you understand the rights that you give up when you enter an agreement?
Yes.
Are you entering the admission freely and voluntarily today?
Yes.
Is anyone forcing you or threatening you?
No.
Has anyone promised you anything other than what's showing on the agreement?
No.
Are you satisfied with the services of your lawyer?
Yes.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No.
Are you admitting the allegations that you violated your probation?
Yes.
All right, I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, the court does find that you are guilty of violating your probation, and the court will reinstate your probation and modify it to include a special condition that you serve 60 days in the county jail with credit for time served. And it appears the state and the defense have stipulated you've already served the 60 days. And all of the original terms and conditions are reimposed. In addition, the court's required to assess a $100 cost of prosecution fee and a $150 cost of defense fee. That includes the $50 application fee. We're maintaining the current termination date of September 3rd, 2032. Did I cover all the terms and conditions?
Yes, Your Honor.
Okay. And sir, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. If the GPS has to be hooked up before you get out, I don't know if you'll get out today. But see Officer Berios before you leave the courtroom, and then as soon as you get out, you need to go to probation to check in. If you can make it before 5 o'clock. If you can't make it before 5, then you need to be there before 9 the following morning, okay?
Yeah.
Thank you. What?
Your Honor, if we could briefly address just the other case I have with Ms. Basso, because I
Oh,
think that's
sure.
the only thing keeping her here.
Sure. That's not Mr. Gates.
Oh, sorry, yes.
Ma'am, we also have violation of probation on Miss Erica Suzanne Cook, case number 232487.
Yes.
She is not present, and Ms. Farkas will let us know why.
Yes, Ms. Cook is sick with COVID and is quarantined. She sounds truly horrible. I asked her not to come to court. She called my office yesterday. We do have a resolution. She's aware of what we're going to be doing. If we could have just one more continuance to make sure that she is no longer contagious.
Given that now we have no objection, Ms. Cook has been in touch with Ms. Farkas. We do, as she said, we do have a resolution. It is not an incarceration.
Okay, so October 21st at 9 o'clock, okay?
Thank you.
Thank you. All right,
I have one more matter unless Mr. Medina wants to go.
Oh,
yeah.
let me go ahead and take Mr. Berios. This is Ariel Berios, 23 CF 1894, and thank you, sir, for your patience. You're here on allegations that you violated your probation. I believe, Ms. Gaynor, this is your case, 23 CF 1894. And first of all, Mr. Berios does not have an attorney, but before I appoint one, the violation, if I'm not mistaken, is just cost of supervision. That's it.
Yes, Your Honor. That's the state's understanding that it's just some costs that are owed. The state would have no issues that I'm not sure if we can backdate any cost of supervision to waive some of those costs potentially for probation, if that's possible.
Okay. Officer Perez is nodding, so.
And then any other.
Okay. No, I was just making a record so that I'm not doing anything, I'm not about to do anything that probation doesn't agree with. I'm just making sure that it's on the record.
And then any other outstanding costs that may still be owed that can't be waived, Your Honor, the state would have no objection to them being sent to the civil liens to go ahead and vote and terminate.
Okay. So, sir, I'm happy to appoint a lawyer for you. You have that right. Let me tell you what's going on, and then I'm going to let you make a decision if you want to go forward and have me appoint a lawyer or not. I'm trying to save you some money. The state has proposed that I waive the cost of supervision. It's $920.88. That's the allegation that you violated, is you just didn't pay that cost of supervision. And then that would be a termination of your probation. Let me check and make sure one thing that I didn't write down. I think you have paid all of your court costs, but let me verify, okay?
Yes, ma'am, I have.
I thought you had. Do you show everything on Mr. Berios' case being paid up? I mean, I see payments in there, and I know that if you hadn't, it would have been included in the affidavit, so I'm just verifying.
I show a zero balance.
Perfect. So, would you like me to go ahead and do that and waive the past cost of supervision of $920.88?
Yes, ma'am, I
And
do
then
agree
just
to those terms, and I do not need an attorney present.
Okay, thank you. The court is going to go ahead and, well, I mean, if I'm waiving that cost of supervision, this would be a successful termination then, instead of a revoke and terminate. Wouldn't it? Okay, and I think Mr. Berios is eligible for early termination. I see your request in there, and
My termination date is tomorrow.
oh. It's, wow, okay. I am treating this as a successful termination.
Yes, ma'am.
I am waiving the $920.88 or whatever it is of cost of supervision so that you can just be done.
Yes, ma'am.
Okay. Do I have to impose the cost of prosecution?
If the VOP is not dismissed, then yes, ma'am.
Is the VOP dismissed?
Yes, Your Honor.
Okay, it's dismissed. So that saves you some more money right there. Okay.
Yes, Your Honor, thank you.
Yes, thank you. So you will be considered successfully terminated for your
As of
probation.
today?
As of today. I'm granting early termination a day early. I'm sorry, sir. But congratulations to you.
Thank you very much.
Thank you for taking probation seriously.
Yes, ma'am.
Yes, it's very much appreciated, and good luck to you, sir.
Thank you, Your Honor.
Thank you.
May I be dismissed?
Yes, thank you. All right, to the attorneys, which case would you like to call first? Or next, I should say.
Your Honor, I have surgery tomorrow. I would love to get out of here so
Yes.
I can prepare for the hearing the next day, the 2-hour
Yes.
hearing the next day. So, I have 2 inmates, Bolinsky and Brady.
All right.
But I'm happy to wait, since it seemed like my colleagues were offering.
First up will be Alex Bolinsky.
Your Honors, Alex N. Bolinsky is approaching. This is Steve Medina with Mr. Bolinsky in 25 CF 552. We would
Yes.
like to go ahead and proceed on our motion to set bond. It was dated September 5, 2025 and set for today at the same time. We're in court. I
Okay,
don't know if
just-
the court has a chance to see it. It's super short.
Let me just pull it up.
There is a typo in it. I will have to put on the record.
Hold on just 1 second. I just want to pull it up.
Sorry, Judge.
Oh, no problem.
I'm sorry, Judge, I didn't have an extra copy for the court.
Oh, I've got it right here, and I'm just looking at something.
I had an error in the first paragraph referencing the wrong case. It should have referenced the misdemeanor case, 25 MM 2461, because he was taken into custody in July 22nd, and 25 MM 2461, not 25 CF 552, which is the case in this court.
Correct, and it looks like the first appearance judge found probable cause of the violation and ordered no bond. And let me just look at one other thing.
I'm pretty sure, Your Honor, when Your Honor did an order commanding arrest that was dated July 23, 2025, Your Honor did say no bond?
Let me find that. July 23rd.
Yes, Judge.
That might
It
be.
looks like it was signed, actually was signed by Judge Reed. so
Yes, the
I-
first appearance judge.
Yes, the first appearance judge, but he was taking action, the order commanding arrest in the 25 CF 552 case.
the order commanding arrest was issued by Judge Reed.
I hadn't noticed that until standing here right now.
Okay, so.
Your Honor, it's a very simple argument on our behalf. He has no history of, by the way, another typo in paragraph 4, failure to appear, not failure to appeal. Defendant has no history of failure to appear. He has a local residence. He has pled not guilty in the new law case, which is 25 MM 2461. He's requesting reasonable bond in the VOP case. He has a $2,000 cash or professional bond, and that relates to 25 MM 2461. We would ask that the court consider something similar in the VOP case. I know he's not entitled to bond in the VOP, but we're trying to work it out. He's looking at various options that might involve treatment. So things may go in an amicable way in the new law case, but we would like to get him bond in the VOP case.
Thank you. And just bear with me for 1 second, and I'll hear from the state. Okay, and what's the state's position?
The state would object to any modification of the bond. Probable cause was found in the 25 MM 2461 case while he was out on bond in the 25 CF 552. Your Honor, and I can represent to the court that the 25 MM case, the victim is very adamantly wanting to pursue. The state does have an incarcerative offer in that 25 MM case that is followed by probation. He's not entitled to a bond if you commit new law violations while out on bond. And so the state's going to request that his bond remains the same out of no bond.
Okay, and actually it's a VOP, so.
Oh, Mr.
Bolinsky?
Yes.
Yes, he.
Mr. Medina, were you not going forward on your motion to set bond today?
I think that's what I was arguing. I was arguing the motion to set bond in on the VOP.
Yeah.
And so I think
I
he's not entitled to bond on the
Yes.
VOP. Your argument is
Yes,
correct.
yes.
He's not entitled to it.
No.
We're asking for it because he's not a flight risk.
Right.
I'm not saying that a domestic violence battery charged with PC is not important. It is, but through no contact, through potentially other provisions of the nature that the court could decide,
Yes.
and so forth.
For my reasons stated, Your Honor, the state's asking the bond remains.
With all due respect, the motion's denied. This is a violation of probation. and the court does find probable cause for this new offense of battery, which is in case 25MM2461. I just looked up the case. State's filed an information in that case. They're proceeding forward. I read the arrest report. I also find probable cause. So bond is denied in the VOP case,
Your Honor,
which is 25 CF 552. And I'll note that Mr. Bolinsky pled and got placed on probation on June 9th, and this charge is alleged to have occurred on July 22nd, so about 6 weeks later, maybe not even 6 weeks. So, of 11 months, 29 days probation, so.
Your Honor, may I ask a question of the court as far as the next court date?
Yes.
There is an acceptance already by one facility. He pled out to a misdemeanor in the criminal felony division, so it can't be Keaton or Phoenix House, but he has an adult and teen challenge acceptance. We're going to try to expedite a review at Haven House, so we may get one or more options. We already have one option, and the state is going to reach out to the victim and see if inpatient treatment is something that would help. I think it would probably result in a resolution. Can we do something quicker than October? Is there any way, do you think you could do a contact in 2 days?
The misdemeanor attorney is requesting at least 2 weeks of a continuance for her to contact the victim in the case regarding any type of modification of the offer at this time.
So, I'm in civil trials for 3 solid weeks. Yeah, starting Monday.
Yes, Judge.
As of right now, but civil cases, a lot of times they'll settle at the last minute, so I just don't know what's actually going to happen. And of course, if I have a free week, if some of those cases settle, I will open up a day for miscellaneous hearings or early pleas or whatever. I'll make a day available for that. As I sit here at this moment, the soonest dates I have would be in 2 days, which is not going to work for the new misdemeanor case, from what Ms. Gaynor just said. And then, I have October 16th in the afternoon.
We would ask for October 16 then, if that's the earliest we can do. And of course, we can opportunistically keep in mind that if Your Honor gets a day open, you may be able to swing something earlier.
Yes, so if my trials go away on any of those 3 weeks, and it is looking like the greatest possibility of that happening would be next week. So it's still going to be less than the 2 weeks that the state's requested.
Yes, Judge, and I think he has an early October docket day in the misdemeanor case.
Okay.
So I think maybe that October 6th. So
well, what I'm going to do, just so that I'm not going to mess up my docket, I'm putting Mr. Bolinsky on the normal court date, which is October 21st.
Okay.
But if you work out something, then we can move it to October 16th in the afternoon, or if I am able to open up a day sooner, if the civil trials go away on any of those 3 weeks, I'll open up a day. And if it can be brought in sooner, we would absolutely do that. But rather than get the docket out of whack, I'm just going to set the normal court date.
Okay, Your Honor,
with the option, of course, to move it up if you have a deal worked out.
Thank you, Your Honor. Will that be 9 a.m. on
October 21st at 9 o'clock.
And that'll be without subpoenas because we're trying to work it out.
Yeah, just a regular, like what we're doing now.
Thank
so,
you.
Sure, and just call Amanda and in fact, when y'all file notices of hearing, if you could send a courtesy copy of that to me and Amanda too, even though it's in the court file, that way it can help us.
Right, and if the state will please let us know if the misdemeanor lawyer has victim contact that's favorable to a resolution. Thank you.
Thank you.
Next up is Deontay Bradley.
Okay.
Your Honor, Deontay Bradley's before the court. There is a evaluation pending. I think it's Dr. Zeman. And I don't think it'll be very long, but it hasn't been completed as of today, to our knowledge.
Okay, and,
Dianante in Bradby in 25 CF 1317, 25 CF 1477, and 25 CF 1478. I think he could probably stay on October 13, or excuse me, it'd be October 15 if he's in custody. If we need a status.
you mean October 21st?
Well, I think they're new law cases, so
Oh.
if you wanna, Your Honor, these are all new laws, so I
Okay.
think it would be October 15.
Okay. Then we will do October 15th.
And it could just be the regular pretrial calendar as
Okay.
far as the time of day and so forth, I think, Your Honor. It's
Yes,
just
9 o'clock.
But we understand where we need to get that evaluation before we can make any other progress.
Yes, and I saw that I appointed Dr. Zeman on August 15th, so we don't know if the evaluation has been done?
I do not, I know that we don't have it, we'll reach out, but I don't know if it's been done.
Do you remember, sir, if a doctor has come to see you and talk to you in the jail?
Actually, it was only one. It was actually, I believe, on the 11th.
Oh, okay,
About a month in between from now.
okay. The 11th of September, like just a few days ago, last week?
No, more like
August?
month and a half. Yes.
Oh, okay, that might be something different. So, okay, we will follow up and see what's going on, but a doctor's supposed to come see you, Dr. Zeman. Yes, thank you, sir. October 15th. At 9 o'clock will be the court date. This is Bolinsky, thank you.
I'll reach out on the Dr. Zeman issue. Your Honor, may I be excused?
Yes, thank you, Mr. Yeah, I do see another case, actually, but I'm thinking that this one should have maybe fallen off. I have Jackie Brooks.
Yes, Brooks transported is my understanding. I think it was Phoenix House.
Project Hope.
Project Hope, oh yeah.
So
yeah.
he's gone to Project Hope?
Yes.
Okay, that's
yeah.
wonderful. He was just here for a status in case he hadn't gone to Project Hope yet.
And Judge, just can I approach real quick?
Yes.
Mr. Brittine?
And let me put Mr. Brooks's case numbers on the record so that everything's clear. 25 CF 1007, and he had another one. It was, sorry, let me find it.
10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands,
Hair, sorry, on my hair with Mr. T.
Okay, that would be 22 CF 228 Velma Hair. And the defendant is present.
Yes, sir. Travis on behalf of Ms. Velma here. At this time, Your Honor, we're going to enter a denial, and that's that it continue without subpoenas.
Okay. Good morning, ma'am. I'm Judge Clark.
Good morning, Ms. Clark.
So we will schedule your next court date for October 21st at 9.
Thank you, Your Honor.
Thank you.
Right this way,
Thank you,
ma'am.
ma'am.
Next up should be Anthony Gainer.
All right. All right, that would be 24 CF 2519.
Yes, Your Honor, and it's my understanding that we also have a plea agreement that'll be covering his misdemeanor case as well. That's
All
going to be 25 CT 1163.
Okay.
Yeah, that's on 6 months. Yeah, that's on the DOI. Obviously, the refusal is there. I don't remember which on the refusal. Okay. Yeah, just have the probation first. Okay. Sign there, take that. That's your copy. No, this is the one. This. Just so you're talking 5. Waiting for another signature, Your Honor.
All right.
Here's a score sheet.
They don't score, but you get close. Right? I may approach, Your Honor.
Yes.
And I reviewed the score sheet with Mr. Gainer, we had no objection to the score sheet.
driver's license. Okay, it's a 6 months, so yeah, don't know on that.
He was asking about the timeframe on that, Your Honor. I know there's a license suspension associated with the DUI as well as the refusal that he's got to deal with, but my suspicion is he'd be able to get his business purpose license at some point once those are done.
Yeah, I don't know. That's something the Department of Highway Safety and Motor Vehicles does. I have no control over them because they're a state agency, so you'll have to follow their requirements, whatever their criteria is. I would have no objection to you getting a business purposes license if you qualify for it. So, but I don't control whether you qualify or not. So,
Yes, Your Honor, it sounds like he understands he's good with that, then, Your Honor.
okay. So in accordance with your agreement in 24 CF 2519, there is an adjudication of guilt on counts 1 and 2. Previously, it looks like it was adjudication withheld. And we will reinstate and modify probation on count 1 so that it will be concurrent with 25 CT 1163, and the court is imposing a $100 cost of prosecution fee, a $150 cost of defense fee, that includes the application fee, and all previous terms and conditions are reimposed. On count 2, and there's a waiver of cost of supervision. Is probation okay with that waiver of cost of supervision? Sure. Okay, thank you. In count 2, probation is revoked and terminated on that one, correct?
Yes, Your Honor.
Okay,
With the
yes.
sentence of the 6 months county jail. Or
And
5
this
months
is
county
5
jail.
months. 5 months county jail with credit for time served. That is in the misdemeanor count, which is count 2 of 24 CF 2519. So, sir, you're just going to continue on probation in the 2024 case on count 1 only, and you're going to do the jail time on count 2, and then no probation to follow that jail time on count 2.
Yes, Your Honor.
All right. And then in 25 CT 1163, there's an adjudication of guilt. You're placed on probation for 11 months and 29 days. That'll run concurrently with count 1 of 24 CF 2519, waiver of cost of supervision. And is it $476.73 in court costs?
Yes, ma'am.
Okay, $476.73 in court costs, $500 fine, $100 cost of defense fee. Would that be $50 actually?
I did it as my normal 100, Your Honor.
Okay.
I felt like I worked that case a little bit during the course of the VOP.
Okay, yes, and the court will impose the amount in the agreement. And the court is imposing 50 hours of community service work, due at a minimum of 5 hours per month, which will be started 2 months after your release. That's going to be cutting it kind of close.
Yes, Your Honor. He's also asked about buying out the community service work hours. I didn't, the court would have an objection with that. I also told him to check with probation too.
Any objection from?
No objection to him buying out the community service hours.
You can buy those out, talk to probation about it, make sure that, and I cannot remember if it's $10 or if it's minimum wage. I think it's minimum wage, but.
It is, Your Honor.
Whatever the minimum wage is.
It was $10 last time I had to do it.
You know, I think at one time the minimum wage was $10, but the minimum wage has gone up, so I think it's whatever the minimum wage is now. So it might be a little more than 10.
It went up this month.
Is it $14 now?
It should, because it goes up every September until it gets to 15. So I
Okay,
think
so.
this is 14.
Okay. So whatever the minimum wage is, you can buy out the hours. If you don't buy them out, you need to do a minimum of 5 hours per month, which starts 2 months after you get out of jail. How much credit are we talking with?
Your Honor, he's got roughly about 90 days credit, so he's got about another month left to serve.
Okay, all right, because I was thinking, you know.
And the hope is he may get in the blue pod and get out a little bit sooner than that as well.
Okay. All right, I just wanted to make sure there was going to be some time. If he wanted to work the community service, he'd have time to do it.
If the court would just announce that any outstanding community service work could be rolled over into the outstanding probation and felony case, that may make that a little easier for
Yes.
probation as well.
I want Mr. Gaynor to do the minimum 5 hours per month. You could do more than that. But you have to do a minimum of 5 hours per month. But depending on your release date, if you're not able to finish all of it or buy it out by the time your probation expires in 25 CT 1163, you can finish it at the same rate, a minimum of 5 hours per month in the CF case. Now, I have no idea how that's going to be worded in order, but is that doable, Officer Perez, that he could?
Yes, it is doable.
Okay. Okay, thank you. I just didn't want you to violate if you stay in jail and, you don't get out when you think you are, it's a little later or something, and then you run out of time and you're not able to buy it out. I didn't want you to be violated for the community service. I wanted you to have additional time, as long as you're doing that minimum. All right. You must complete DUI school and a victim impact panel. Your driver's license will be suspended for 6 months in 25 CT 1163. Now, I think for a refusal, if there's a refusal.
And he was not officially charged with that, but I did explain to him that the DMV is going to suspend it anyway, and that was part of the conversation we were having about the timeframes for the suspension.
They may suspend it independent of whatever we're doing here today. They
Yes,
could
Your
do it through their process, and it could, isn't it a year?
I think it is, Your Honor, and I explained that to him, and I think he's got to request the hearing within 30 days of the arrest, which wasn't done, so it's likely already been suspended at this point.
Okay. So do you understand, sir, that the Department of Highway Safety and Motor Vehicles has their own mechanism and process that they can suspend somebody's license no matter what I do here today?
Yes, Your Honor.
For however long under the statutes, they can do it. So I don't control them. So even though we're saying 6 months suspension, that's part of your plea agreement, but the Department of Highway Safety and Motor Vehicles can suspend it for longer under different grounds. You
Yes, Your Honor.
understand? Okay. I just want to make sure you understand, because that can be a little confusing. 10-day vehicle impound, which can be waived if the defendant provides proof that he doesn't own a vehicle. So if you don't own a vehicle, you need to provide proof of that to probation, and they'll relieve you of the 10-day vehicle impound.
I don't have one.
Okay.
How do I prove that I don't have one?
The probation knows how to get that done. There's usually a
Probably
form.
search or something?
There's a form I think they can fill out that'll allow them to get that information.
It's through the DMV. The
Okay.
DMV does a search
Okay.
of registered vehicles, and
Okay.
then they provide a waiver,
Okay.
and the state signs off on it.
All right. There you go.
Okay, thank you. Did I leave out anything on either case?
No, Your Honor.
All right, so sir, you have 30 days to appeal the order of the court in both cases. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. And when you get out, you need to immediately, as soon as you can, go report to probation. Also see Officer Varese before you leave the courtroom, okay? Thank you.
This is Parker Durant. Yeah, this is Mr. Parker Durant before the court in 20 CF 2010 and 20 CF 2356.
Yes.
We did reach out to the court about a potential plea agreement in this case. I know the court was kind of hesitant at the bond hearing, but we were able to work out a plea agreement. Just so the court understands, it is a guideline sentence. However, Mr. Gree has never actually been to DOC before, so I think that was kind of the reason we were hoping the court would be inclined to take it, because it is a DOC sentence and it's not something he's ever had before.
Yes. Guidelines, you said?
Yes, Your Honor.
Okay, yes. Yes. Does this include, I know there's a new law case in Crestview.
It's been dismissed, Judge.
Oh, okay.
That's why we're still here, Your Honor. It was dismissed.
Okay, I looked at it last night, and I guess the paperwork just hasn't caught up with it, but,
Yes, Your Honor, and I don't know if the state's received it, but we received a drop charge affidavit from the victim in this case.
Okay.
From RCC. on
Yes, yes.
that. I was
Ms.
quite-
Jaquette.
Mr.
sent it over.
Jaquette provided that to all of our offices,
okay, that's good.
and I think that's what facilitated the resolution here, Your Honor.
That's good.
And Your Honor, we reviewed the score sheet, no objection.
Thank you. Yes, thank you so much. Thank you.
No more probation. We'll officially get off. That's the first time in 5 years. Which one did you do? What you want? Go where you want.
I'm working off of the amended affidavit, but I'm a little worried that it might not be. Let me log on and make sure I've got the most recent one. Okay, so we're here in case 2020 CF 2010 and 2020 CF 2356. Both of those are violation of probation cases. And I'm looking at the second amended affidavit of violation of probation. It was filed on August 15th, 2025. It contains 6 allegations. So which ones will he be admitting to?
I think we would be admitting to all the allegations other than the new law arrest that was either dismissed or will be dismissed, Your Honor.
That is allegation number 5, and it's battery by a person detained in prison or jail facility. Is that the one? Okay.
Yes, Your Honor.
So number 1 and 2, just so that we're all clear on what the allegations are. Number 1 and 2 have to do with testing positive for illegal substances.
Yes, Your Honor.
Number 3 is failure to report. That would be, the alleged date is April 4th, 2025. Then number 4 is absconding, changing residence. That's also alleged to have occurred in April approximately. Then 5 is the new arrest, which
Yes, Your Honor.
would not be admitted to today. And then number 6 is failing to pay cost of supervision and fees. And it was alleged that as of August 14th, that Mr. Guerrero was in arrears by $230.16. So will Mr. Guerrero be admitting 1, 2, 3, 4, and 6?
Yes, Your Honor, and agreeance with the plea agreement that's been filed, Your Honor.
Yes, okay. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll state your name, please.
Parker Jameson Gurria.
Thank you. In the 2 case numbers I just listed a few minutes ago, it's alleged that you violated your probation, and I just read out what the allegations are. Have you had a chance to talk to your lawyer about those allegations that you violated your probation and any possible defenses you might have?
Yes, Your Honor.
All right. Did you discuss the plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on the next to the last page?
Yes, Your Honor.
Thank you. Do you understand the rights that you give up when you enter an admission to a violation of probation?
Yes, Your Honor.
You're giving up your right to have an evidentiary hearing and make the state prove the allegations. Do you understand that?
Yes.
All right. Are you entering the admission freely and voluntarily today?
I am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, he did.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I do have a score sheet. It shows 50.9 total sentence points for a lowest permissible prison sentence of 17.175 months in state prison. Any objections or corrections?
There you go.
Sir, are you admitting to the allegations that I read out a few minutes ago? It's allegations 1, 2, 3, 4, and 6 on the second amended affidavit.
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. And in accordance with your agreement, the court finds that you are guilty of violating your probation, and you were previously adjudicated guilty of the underlying offenses, if I'm not mistaken. Okay. In 2020 CF 2010, probation is revoked and terminated. And on each count, you will be sentenced to 17.18 months in state prison, Department of Corrections, with credit for time served. And this will be concurrent with the next case, which is 2020 CF 2356. And both counts are concurrent as well. And there will be a $100 cost of prosecution fee, $150 cost of defense, and that includes the application fee. And in 2020 CF 2356, there's a previous adjudication of guilt. Probation is revoked and terminated. You are sentenced to 17.18 months Department of Corrections on each count. They're concurrent with each other, and concurrent and coterminous with case 2020 CF 2010, and you'll have credit for time served. $100 cost of prosecution fee and a $100 cost of defense fee. Those fees and costs that I've imposed on both cases are in addition to anything previously imposed that still remains unpaid. So essentially, every count, both counts in both cases, the DOC sentence is imposed with credit for time served. All the counts are concurrent with each other, and the cases are concurrent, but then 2020 CF 2356 will be coterminous with the 2020 CF 2010 case.
Yes, Your Honor.
Okay, so essentially, Mr. Garea is getting the credit in the 2020 CF 2010. He's getting that credit in the other case as well.
Yes, Your Honor.
Basically. Okay. And then, sir, you'll have 24 months after you get out to pay any outstanding court costs on either of these cases before they go to collections. If they go to collections, they're going to affect your driver's license. Did I cover all of the terms and conditions?
Yes, Your Honor.
Okay, any questions about it? Okay, all right. Good luck to you, sir. You have 30 days to appeal the order of the court. If you need an attorney, I'd be happy to appoint one for you. You're entitled to one. Good luck, sir. Thank you. This is a score sheet on previous ones that I hopefully I've signed it. And here is
Your Honor, this is Mr. Jamarcus Hall before the court, 19 CF 849. We have a plea agreement to be filed in his case.
all right.
And Your Honor, this is only going to count towards count 1 of the case. Counts 2 and 3 were consecutive probation. They have not been violated.
Okay.
It is a DOC guideline sentence with credit. Mr. Hall's got some credit, so my hope is that he'll be released somewhat soon, and he's been informed he'll report to probation immediately upon his release.
Okay.
Well, I don't see Mr. Dina. If they do, I'll quit too. They've already, I'll quit too.
May I approach, Your Honor, with the plea agreement and score sheet?
Yes, thank you.
And we have no objection to the score sheet, Your Honor.
Okay, thank you. Thank you so much.
Don't go back to Marcus. Yeah, too. There's Christine Rosso and Jessica Turner. Sure does. Yeah, right now she's back.
All right, so if you'll just raise your right hand, sir. Thank you. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. So you're here in case 19 CF 849, and it's alleged that you violated your probation as to count 1. It looks like, let me clarify with Officer Perez. The warrant or the affidavit has all 3 counts listed, but would we only be here on count 1? Or?
I believe that's what the agreement says.
Okay.
Yes.
Okay, thank you. So as to count 1, the charge is felony battery. And there are 9 allegations of violation of probation, and that is the amended affidavit that was filed on July 9th, 2025. Will your client be admitting to all of them?
Yes, Your Honor.
Thank you. Sir, have you had a chance to talk to your lawyer about the allegations that you violated your probation that are listed in the amended affidavit that was filed on July 9th?
Can I talk to him?
Yes, did you discuss those allegations that you violated your probation with your lawyer?
Yes, ma'am.
Okay. And did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
I might need you to speak up just a little bit.
Yes, ma'am.
Okay, thank you. And is this your signature on the last page?
Yeah, GHHL.
Let me have court security bring it to you to make sure. I know it's a long way away. Let's make sure that he verifies his signature on that. Is that your signature, sir?
Yes, yes.
Okay, great. Thank you. Do you understand the rights that you give up when you enter an admission to a violation of probation?
Yes, ma'am.
You understand you're giving up your right to have a contested hearing?
Yes, ma'am.
All right. Are you entering the admission freely today?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right, and the score sheet shows 60.1 total sentence points. It shows the lowest permissible prison sentence of 24.075 months. And sir, are you admitting all of the allegations that are listed on the amended affidavit entered or filed on July 9th, 2025? Are you admitting all of the allegations? There are 9 of them.
Yeah, you're admitting all those violations before the court. Oh, yes, ma'am.
Okay. I accept your admission. I find it was freely and voluntarily given. This is to count 1. I think there's already been an adjudication of guilt.
There was,
yeah. Probation is revoked and terminated as to count 1. And you are, well, the court finds that you are guilty of violating your probation as well. You're sentenced to 24.075 months Department of Corrections with credit for all time served. I believe there's more credit. I had a note of 41 months credit.
Yes, sure.
So the court is imposing $100 cost of prosecution fee, $150 cost of defense. That includes the application fee as well. Now, you're still on probation on counts 2, or, well, it hasn't started yet, but those 2 other counts, counts 2 and 3, you have, I guess, 5 years consecutive probation, so a total of 10 years of probation remaining on those 2 counts. That starts on your release from incarceration. So as soon as you get out, you need to go see probation.
Yes, ma'am.
Okay? And you also need to see Officer Varese before you leave the courtroom today. Did I cover everything? And
No, you covered everything.
okay.
Question, so the court costs for count 1, will that just be during probation or?
Good question. The court costs that I just imposed on count 1,
If we can have those due during the term of probation, yeah.
yes, we will have those due during the term of probation. So let me make sure Officer Varese is aware. The court costs that I just imposed will be paid during the probation. So good luck to you, sir. You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Thank you, sir.
Roger Harris.
All right, and we're here on case 24 CF 1351 and 25 CF 1200. Mr. Harris is here, and we were set for a status today or possible resolution, and I think it had to do with Keaton.
Yes, Your Honor, and we've had some issues with Keaton, and so the state and I were able to negotiate a plea agreement in lieu of that, Your Honor.
Okay.
Do you have a score sheet?
I do.
I'm just hoping you do.
Jessica always gives them to me.
Your Honor, may I approach?
Yes.
Score sheet. Looks like he scores. School. Downward departure.
I was reviewing the score sheet with Mr. Harris, Your Honor. He does score 13 months, but this will be a downward departure for a plea agreement.
Your Honor, this is a legitimate, uncoerced plea bargain.
Okay, thank you. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
Yes, ma'am, I do.
Thank you, sir. You can put your hand down. And if you'll state your name for me, please.
Roger Lee Harris.
Thank you. In case 24 CF 1351, I am looking at the affidavit of violation of probation filed on June 17th, 2025. There's one allegation that you violated your probation, and that is the new law arrest, which is the basis of case number 25 CF 1200, where you're charged with possession of a controlled substance, which is a third-degree felony. Have you had a chance to talk to your lawyer about the allegation that you violated your probation and also your new offense of possession of a controlled substance?
Yes.
All right. Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand that you're giving up your right to have a trial in 25 CF 1200?
Yes, ma'am.
And do you understand that you're giving up your right to have an evidentiary hearing in 24 CF 1351?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I do have a score sheet that shows 46.2 total sentence points with a lowest permissible prison sentence of 13.65 months, and you stated no objection, is that right?
No, ma'am.
Okay. And no objection, or no, that's
No
not?
objection, Your Honor.
Okay, thank you. Is there any exculpatory DNA in 25 CF 1200?
No, ma'am.
All right, I do find a sufficient factual basis in that case, based on my review of the documents in the court file. Sir, if you are not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am.
All right. In 24 CF 1351, are you admitting the allegation that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In 25 CF 1200, how do you plead to count one?
Guilty. No contest. Or no contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt in both cases on all counts. And I do find that you are guilty of violating your probation in the 2024 case. In that case, 24 CF 1351, probation is revoked and terminated. You are sentenced to 8 months in the county jail with credit for time served. That'll be concurrent with the 2025 case that I'm about to talk about. And I'm imposing a $100 violation of probation cost of prosecution fee and a $150 cost of defense fee. That includes the application fee, and those costs are in addition to anything previously imposed in 24 CF 1351. In 25 CF 1200, there will be an adjudication of guilt, and you are sentenced to 8 months in the county jail with credit for time served. This will be concurrent and it will be coterminous with 24 CF 1351. And is it 615 court costs?
Yes, ma'am.
Okay, $615 in court costs, $100 cost of defense, and the adjudication of guilt will likely result in your driver's license being suspended. Do you understand that, sir?
Yes, ma'am.
Okay. You'll have 24 months after you get out of jail to pay the outstanding costs and fees in both cases before they go to collections. If they go to collections, that'll further affect your license. You have 30 days to appeal the order of the court in both cases, and if you would like me to appoint a lawyer, I'd be happy to do so. Good luck to you, sir. Thank you.
Right, sir. Next up will be Michael Ollie.
And this is going to be Mr. Michael Hawley before the court, 21 CF 2411. And we have a plea agreement to be filed in Mr. Hawley's case.
Okay.
May I approach, Your Honor?
Yes.
Within no score sheet, and this one says it's a modification of his outstanding supervision.
Okay, thank you. There is a request from the sheriff's office for reimbursement for transportation.
Yes, Your Honor, and I, realizing it as you said that, I did not incorporate that in the plea agreement. I don't think Mr. Hawley would have any objection to that being assessed and due during the term of supervision.
Okay. Is that accurate, sir?
Yes, ma'am.
There's a request for reimbursement. It's for transportation of, I believe, a witness. And this must have been,
I think it was, Mr. Hawley was arrested in a different county and transported back for the VOP warrant.
actually, let me look at something because,
Looks from the Marion County Jail, ma'am, Ocala.
yes, but there's a different name at the top. It says defendant's name.
That says Jessica Ann Jones on there.
Yeah.
Oh, that was when
That was
they pick up somebody else.
I just got you while you were there.
They got me and they went to a female prison. The female had already been picked up.
Okay.
So
Well, I think that person was I don't know if she was a defendant or a witness.
No, you're
But
right.
I recognize the name from another
What-
case.
What it sounds like is they prepared it ahead of time and got Mr. Hawley at the same time. When they went to get her, she was not there. Instead of changing that, they submitted hers in his case. And I'm sure if you look at her case, it may have his in there.
I want to say she was,
She was not a witness in this case, or as
right, in a different case.
Yes, Your Honor.
Does Mr. Hawley have any objections, sir, to the amount of the plea?
No,
that's accurate?
if,
Okay.
I would put it this way, that amount, or if the court's inclined to have the sheriff's office submit an appropriate one with the right amount, we wouldn't have an objection to that either. My suspicion is going to be about the same amount anyway.
Okay. Where was Mr. Hawley picked up from?
Marion County Jail.
Orange County?
Was it Orange County?
Orange County.
Okay. So slightly different, I think.
Yeah.
Okay, well, then,
We'll do it this way, Your Honor. We'll stipulate to there being a cost of transportation, and then once we see the amount, we'll likely agree to stipulate to that amount.
okay. I will say reserve jurisdiction to,
Yeah, we'll follow up on that,
Okay.
ma'am. We'll get the corrected one, and I'll give it to Mr. Gates, and then we can go ahead and get that back to the court to get the actual amount ordered.
Yes, Your Honor.
I will say for 60 days. So I will not impose that amount now.
Yes, Your Honor.
I'll let the sheriff's office submit the corrected bill, and I will reserve jurisdiction for 60 days to impose that.
Yes, Your Honor.
All right, so I'm looking at the affidavit that was filed on July 17th, 2025. And it has one allegation. Oh, wait, it says additional, never mind, it's not one. It has, looks like 7 allegations of violation of probation. Will your client be admitting to all of them?
Yes, Your Honor.
Okay. Sir, I cannot recall if I already swore you in, so I'm going to swear you in. Do you swear or affirm the testimony that you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down. If you'll just state your name, please.
Michael Hawley.
Thank you. In case 21 CF 2441, it appears that you have, well, it's alleged that you violated your probation. There was an affidavit of violation of probation filed on July 17th, 2025 with 7 allegations in it. Have you had a chance to talk to your lawyer about those allegations that you violated your probation and any possible defenses you might have?
Yes, ma'am.
All right. Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter an admission?
Yes, ma'am.
You understand you're giving up your right to have a contested hearing?
Yes, ma'am.
Are you entering the admission freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
Are you admitting to all 7 allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. There looks like there was a previous adjudication of guilt on the underlying charges. We're only here on counts 1, 2, and 3 from the original case. The court finds that you are guilty of violating your probation, and in accordance with your agreement, the court will reinstate and modify your sex offender probation. It says waive cost of supervision. Is probation okay with that?
Yes, we are.
Okay, thank you. And I'm adding the condition that you reside with the Master's Touch program, and you'll need to report to Master's Touch within 48 hours of your release after you report to probation. Now, how's he going to get there? Does he have a way to get there?
That was one of the conversations the state and I were having. We're going to give Mr. Hawley a little bit of leeway on this and have him make his own arrangements to get out there. That's why I asked for 48 hours from his release to make sure we have all that. It's my understanding I also have a GPS, so we should be able to track him down if there is an issue as well.
Let me see what Officer Berios has to say about
Your
that.
Honor, it costs $300 for a deposit plus $200 for the first week. So without the $500, he's not going to be able to move into Master's Touch. He also has to complete a essay. Did he do that?
That would have been part of the original agreement, and Master's Touch has already agreed and has approved and has a bed for him as we sit right here, right now. Otherwise, would not have done any of this.
Okay. Also, Master's Touch is not a program. It is a halfway house that's faith-based. So just so you know that there will not be a completion certificate, right? Okay.
That's fine, as long as he lives there.
That's why I specifically put in the plea agreement, reside at. I didn't say complete or enroll, I simply said reside at, because I'm aware it's simply a halfway house. And that's what Mr. Hawley's been asking for, is just a place for him to be able to live and to get back to a normal life.
So that fee, or $500, it sounded like, was it 500?
Yes, it costs $500.
That'll be something between Mr. Hawley and
So that's worked out? You have a way to?
Yes, Your Honor. That would have been part of the interview process with Master's Touch, and they have
work that out, otherwise I wouldn't. But
Okay.
you'd be up here asking the court to sentence him with those terms.
Okay, I'm just making sure, I don't, I know you've already covered all the bases, but I'm
Yes, Your Honor.
just making sure and making sure we have a good record.
Yes, Your Honor. And full candor with the court, the hope is with Mr. Hawley, eventually he'll have enough money saved to where he can transfer supervision back to North Carolina. That is where his family resides. And by getting him a place to stay, that's the hope, is that starts the process to do that.
Okay. So, sir, do you have a way to get to Master's Touch?
Yes, ma'am.
Because it's in Pensacola, correct?
Yeah, my mom, I'm calling her when I get back. Her and Master's Touch is already,
Okay.
I haven't got to talk to her yet, but they're making plans for transportation.
Good, good.
And I've given him the address as well as the contact number for the supervisor with Master's Touch, so he'll have everything he needs.
Wonderful. Thank you. And so you'll have to have that GPS installed before you get out. It's probably, I don't know if they can do that today or not, it might be tomorrow. There's a $100 cost of prosecution fee, a $150 cost of defense fee. All of your previous terms and conditions are reinstated, and I'll reserve jurisdiction for 60 days to award reimbursement to Okaloosa County Sheriff's Office for cost of transportation upon their filing of a proper request. And did I leave out anything?
No, Your Honor.
Okay. Sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. I've heard good things about this program, or this place. Good luck.
Thank you, Your Honor.
Thank you.
Judge Clark, I have no further mandates, please.
Yes, have a great day. Actually, Mr. Gates, do I need to set a follow-up date for Mr. Hawley to make sure he got there?
If he didn't do it, ma'am.
If he didn't do it, it's a violation,
Yes, Your Honor,
okay.
so I don't think that'll be necessary.
Okay.
Your Honor, this is Mr. Phoenix Jordan before the court in
Yes.
24 CF 1746, 24 CF 2418, 25 CF 1278. It was set as a Keaton status. We did get an answer from Keaton. He was not approved. However, the state and I have talked about drug court as an alternative. We're in the process of getting him screened for that. He should be transported in the next couple of weeks, and if that works out, he'll come off the docket. If not, then we can set him for the October 15th pretrial date, because I think he's got a new law violation, and we can address status at that point.
Okay. So, October 15th at 9 o'clock.
Yes, Your Honor.
On these three cases, I don't know what the new law is.
It's 25 CF 1278.
Oh, it's on the docket today.
Yes, Your Honor.
Okay, great. Actually, they're all three open, correct? Or
Yes, Your Honor. There are 2 VOPs in the new law violation.
okay. So we're setting everything, all three cases, for October 15th at 9 for pretrial conference. The VOPs will track along with the new law, and hopefully he'll get approved for drug court. That'd be great. And if not, I'll see you on October 15th. All right, thank you. Okay. All right, Mr. Gates, it looks like we have at least one other one on one other case.
Yes, Your Honor. I have Willie Kimell before the
Yes.
court. That is 22 CF 607 and 22 CF 652. He was here this morning. He provided a receipt which showed that one of the cases had been, the outstanding balance had been paid off. He has another case with outstanding balance. The state agreed to continue the case without subpoena so that he could finish making those payments.
Okay.
He actually is a trucker and had his truck parked out front and asked if he could get back to work. The state had no objection to waiving his appearance, so I filed a waiver earlier today for him as well.
Okay, so October 21st at 9 o'clock, we'll continue till then.
Yes, Your Honor.
All right. Any other, what else do you have?
I had one, Your Honor.
Oh, you did?
It was Mr. Paul Gunnels. We had noticed him for today, but I missed it yesterday and forgot to get him transported.
Okay.
It is a plea agreement that would result in his release. If the court would be inclined, I'd like to bring him back on Thursday. I'll be here anyway.
Yes.
And we can take care of it then.
Do you have a case number?
That is going to be 25 CF 1396.
1396, okay. We'll add him to the afternoon docket.
Yes, Your Honor.
Well, actually, Ms. Gaynor, on Thursday morning, I know that we had a discussion with Mr. Medina.
I just received the email, Your Honor. I know he did include you and Ms. Bailey on that. He said he was going to be canceling those hearings when I filed the null pros. I just responded back and attached that null pros, so I imagine we'll be getting an email here just a second saying we can, or a notice of canceling those hearings. It looks like 99% sure we're not gonna have those hearings Thursday morning.
But the reason I'm asking is, and thank you for that, is I'm trying to figure out what time to set Mr. Gunnels. And if the morning is opening up, I'd rather put him in the morning so that that's one less person in the afternoon.
Yes, Your Honor.
That might keep us late.
I will make myself available whenever the court's available.
Okay.
This will be with Mr. Sprout, so.
One of us could be.
I'm here all day on Thursday. I have a sentencing hearing with Your Honor and another sentencing in the afternoon.
Let me look at the docket or let me look at the calendar.
It's possible that the sentencing in the morning, Mr. Thornton, is going to be a negotiated plea. It's going to be guidelines if it doesn't fall apart.
Well, okay. All right, the court we'll address that on Thursday. So it looks like the hearing that we think is being canceled was starting at 10. So how about if we set, and this will be a special set, but we'll set Mr. Gunnels at 10 o'clock?
Yes, Your Honor, and I will make myself available at 10 o'clock to handle that.
Okay. So he will need to be added to the transport list, and I'll have Amanda add him to the docket, but 10 o'clock, September 18th, in 25 CF 1396, and that will be for a resolution.
Yes, Your Honor, we have assigned an executed plea agreement that's for 90 days, which he already has in at this point. I just need to get him in court.
Okay, so let me make sure we get that added. All right?
I think I have the last issue on the docket. Lachey Cooper, 23 CF 1557.
Okay, let me find that. Yes, got it?
Ms. Cooper was here earlier. Ms. Gaynor did lay eyes on her. Her daughter is very sick with the flu, and they're taking her to the hospital, so I requested that she please leave the courtroom. She was here, though. I have spoken with Probation Officer Morales a number of times about this case, and Officer Morales has made an updated recommendation to me and wishes to have us continue the case one more month. Ms. Cooper is attending treatment at Bridgeway, is doing very well, and so Officer Morales wants her to keep going for one more month, and then at the next VOP date, we'll be resolving it by reinstating her probation. Officer Morales has been very involved with Ms. Cooper, and her situation is quite different from what it was a couple years ago when the VOP was initially filed, which is why Officer Morales is now making this updated recommendation, and I've spoken with ASA Gaynor about all of this. So I'm requesting a last continuance to the October date, kind of at the request of probation.
Okay, Ms. Gaynor?
Your Honor, I have no objection. I did speak with probation, or texted with probation this morning. Ms. Morales did confirm basically everything that Ms. Farkas just stated. And I think helped facilitated Ms. Cooper to get here expedited fastly, so I could lay eyes on her. And they did help facilitate in that.
Okay.
I am just jumping onto this case again, but I'm not gonna have an objection at this point of a continuance, just based on the representations from Ms. Morales and that Ms. Cooper is at Bridgeway as of 9/9, staying there.
Just a correction, she's not staying there.
It's outpatient, I believe.
Yes, she's staying with family, but she's going to treatment. She's attending classes and treatment there, so.
Okay, So I had today down as last continuance, but in light of that,
Yes.
we will continue the case one more time
Thank
to
you.
October 21st at 9. Now, she does need to be here. I understand she has a sick child.
Yes.
Thankfully, she was here and Ms. Gaynor saw her.
She's been very much in contact with myself and probation. It was just the
Okay.
sick baby, so.
Yeah.
Thank you, Your Honor, I appreciate it.
Okay,
I
thank you.
think that's everything.
All right. And I see someone sitting here. Ma'am, did you have a case? or-
she's just trying to make contact with Ken, so.
Oh, okay, thank you. I just didn't want to miss anybody. Do you have any that?
No, ma'am, just the 130.
Okay, so we do have a case at 1:30, so we'll be back for that. And it looks like we made it through our morning docket, or the whole day except for the one case. This is fantastic. All right, y'all have a good lunch and a good rest of your day, and I'll see whoever is on the 1:30 case, I'll see y'all back at 1:30.
See you then, Judge.
Did you come back for 1:30?
I don't think so, it's just a restitution hearing. So,
Well-
unless,
The restitution is payable through probation.
Oh, well-
No.
I'll be back.
okay.